I would like to say welcome to fellows, colleagues, wherever you are around the world. It's wonderful to see so many old friends and new friends on the participants list. The title of the seminar, I think, is something that we should dwell on briefly before we start. As many of you will know, the Royal Anthropological Institute has been greatly fortunate in developing a program of forensic anthropology certification over the last decade. And this has resulted in an enormously important body of knowledge and practice being developed, whereby we can begin to help recognize the outstanding forensic anthropologists in Britain and potentially also abroad. And Dame Sue Black, who has been so instrumental in the success of this program, is with us today. And I'm very pleased that she can be so. Now, what is so absolutely fascinating about this is that we rather assumed that forensic anthropology would have to be predicated around the physical anthropology that we commonly understand through the use of that term. Although, of course, we also know in the abstract that social anthropologists do appear in front of the courts. What we have today, though, is a deliberate attempt to think about what has to happen to social anthropology to make it successful in terms of the evidential basis of any presentation that a social anthropologist might feel necessary to give to the court, and indeed that the court might feel necessary to receive from a social anthropologist. So colleagues will see immediately the enormous importance of tackling this subject explicitly, as our speaker is about to today. And we really are extremely grateful to him that he can be with us and help us begin to think about these issues. And it really is a beginning. Now, our speaker, Dr. James Rhodes, is Senior Research Fellow with the Melbourne School of Population and Global Health, Faculty of Medicine, Dentistry and Health Sciences at the University of Melbourne. He specialises in forensic social anthropology with a methodological focus on network-based population dynamics, social and kinship network analysis, geographic information systems and data governance. Dr. Rhodes has built up 2 decades experience working with Indigenous communities across Australia on issues of culturally oriented legal restitution and compensation. And it is with great pleasure that we invite him now to take the floor. Thank you very much.
Wonderful. Thank you so much, David, for that very generous introduction, and hello, everybody. It's wonderful to be here, but it's also wonderful to hear about the warming weather in the Northern Hemisphere, because down here in Melbourne, on the southern side of the planet, we are sliding inexorably into winter, and it is also dark where I am. Without much further ado, I'd like to acknowledge the Institute and the great work that it does internationally, the fantastic guiding role that it plays for all of us as social and physical anthropologists around the world, and the inspiration that it provides for the advancement of the discipline. If everyone gives me a minute, I will attempt to bring to the screen the PowerPoint that I am going to be using today. Okay. Now, hopefully everyone can see that. I'll just see if I can get a confirmation from...
Looks perfect, yes.
Fantastic, thank you, Hanee. Okay, so as David said, the webinar today is titled Forensic Social Anthropology, which may come as an unusual combination of words for some in the audience. Normally, when we hear the word anthropology and the word forensic in the same combination, we assume that we are, of course, talking about physical anthropology. But in Australia and in some other parts of the world, to a lesser degree, social anthropology is regarded with a similar degree of seriousness, I suppose, by courts at various jurisdictional levels in terms of the expertise we bring to bear. So for the introduction in this paper, I'm going to begin with an outline of the basic terms and definitions that I'll be using throughout. Forensic science really is the most important place to start, because it is the expectation of courts everywhere that forensic evidence comes from a scientific basis. Social anthropologists have acted as expert witnesses in court proceedings for many decades. However, There has persisted throughout that period a tension between social anthropologists' readiness to accept the assignation of expertise by courts and the typical manner in which courts characterise such expertise as the forensic specialisation of an established scientific field. Forensic science is, of course, the specialisation of any given established field of science that relates to the investigation of matters subject to legal proceedings. And in most cases, these are criminal and usually involve activities that have led to death. Forensic physical anthropology, which is, as David has acknowledged, simply shortened most of the time to forensic anthropology, is a specialised branch of that field that has developed to provide expert evidence most commonly in relation to police investigations into casualty events, where typically skeletal remains of one or more casualties is amenable to what we would call biometric study, including mainly in this case, osteological and taphonomic analysis. By contrast, however, forensic social anthropology, especially here in Australia, is a specialised branch of that field which has developed to provide expert evidence most commonly at this time in relation to civil rather than criminal matters, where the culture of one or more parties' social relations is amenable to what we would call sociometric analysis. Now, because of the application of social anthropological expertise to civil matters, legally empowered tribunals are often involved in Australia instead of, or in addition to, courts. Forensic social anthropology, as we've noted, I think is uncommon outside of Australia, and it is used here predominantly in the resolution of litigation and negotiation connected to Indigenous community claims to land, as well as waters and the natural resources contained therein, which follow from the colonial expropriation by the British Commonwealth in the history of this country. So in this webinar, a broader assessment of the key principles of forensic social anthropology is going to be presented. And the point of this exercise is to provide both a wider Australian and an international audience with a perspective that may be used outside of these existing frameworks, both in Australia and elsewhere, but also in relation to other relevant legal proceedings internationally. So what I'm going to do next is to quickly outline the relationship between science and anthropology as a domain, and that's the domain within which we find the disciplines or the fields of both social anthropology and physical anthropology, followed by a quick history of how we got to this particular situation where we require an explanation of the distinction. Since the 1960s, there's been a broad convergence in the understanding that a conciliant scientific domain of any kind, briefly, is a discrete area of research into what we would call an object. You can see on the left-hand side of the screen here, I've color-coded these in a consistent manner. It's a discrete area of research into an object within the scope of a given set of what we would call spatio-temporal parameters, which is supported by a theoretical model of causality. Now, we may be able to construe a cladistic model of forensic social anthropology's specialization as visualized in this image, such that there are two transitions, one from the domain of anthropology into the discipline or field of social anthropology and alternately physical anthropology, and then a further transition of that field into the specialized domain of forensic social anthropology. And at each transition, there are modifications that occur to all three elements of the paradigmatic basis for the field and the parent domain within which it sits. So there is broad consensus, I would say, that the object of anthropological research at the level of the domain is variation between human communities. There is also broad consensus that the parameters of this research domain are measurable geographic space and historical time, so that anthropology construes variation between human communities as occurring on a spatio-temporal axis, where a given community that is defined by a distinctive set of variations can be linked to a specific region in geographic space and historical time. This consensus among anthropologists is consistent with other domains of science, each of which is confined to a delimited spatio-temporal region as part of its paradigmatic definition, ranging along a continuum between subatomic and cosmic scales. However, where anthropology deviates from other scientific domains is in its model of causality, being that explanatory model that predicts the outcomes of empirically observable processes. For example, in physics, the causal model focuses on the interaction of matter and energy. In chemistry, the causal model focuses on the interaction of electromagnetic forces. And in biology, the causal model focuses on cellular function. In the domain of anthropology, however, there is no unified causal model for predicting variations between human communities. Instead, the single research domain, defined by the single object of variation among human communities, splits into two fields: physical anthropology and social anthropology, each with distinct and importantly distinct causal models. Why is it important that this distinction is foundational to the domain? At the inception of the domain of anthropology, in the 1870s, more or less, biological evolution was assumed to be the exclusive cause of variation between human communities, suitable to predicting variations in both human physicality and sociality. The origins of this assumption reside in the autochthonous culture of anthropology's British and North American founders, who we might say were, for argument's sake, Edward Burnett Tyler and Lewis Henry Morgan, most importantly, which is an event, thankfully, that is outside the scope of this paper. However, the effect of this monothematic causal model on the domain of anthropology and on its influence in colonial administrative policy of the late 19th and early 20th centuries has been profound, remaining broadly unquestioned, as it was since that time until the revelations, we might say, of genocide committed during World War II and their justification on concepts that, if we're honest with ourselves, evolved out of anthropological theories and took on the form, of course, of ideologies. From the 1950s onwards, two models of causality have emerged within the previously unified domain of anthropology, one based on biological processes and the other on cultural processes. The distinction in causal models is also the source of the respective binomial titles of the two child fields that emerged within the parent domain of anthropology, where physical anthropology is also known as biological anthropology, and social anthropology is also known as cultural anthropology, especially in the USA. Because of this bifurcation in causal models, while the field of physical anthropology has been enveloped by the domains of various natural sciences, where biology also forms a common causal model, especially and importantly, medicine, social anthropology has remained embedded within the humanities. Following a post-war fluorescence, which we might say was led in Europe by Levi-Strauss, by Raymond Firth in Britain, and George Murdoch in the USA, of course, among others, during which time social anthropology also appeared to be moving closer towards professional scientific formalization and empiricism. Between the 1950s and 1970s, what we might call mainstream social anthropology ultimately metamorphosed into a philosophy of culture rather than a science of culture. To this day, the definition of culture remains a point of contention within the field of social anthropology, even in Australia, where forensic anthropology is accepted by the court system as a relevant scientific expert field. Despite the drift of mainstream social anthropology into philosophy, scientifically oriented formal empirical social anthropology has continued to be taught internationally at various universities, including, for example, the University of California, LHS, the University of Texas, and in other places. And of course, the American Anthropological Association is also home to a robust and growing society for anthropological sciences, of which I'm a member. Now, the science of social anthropology. What are the impacts or the implications of this three-part model of science for social anthropology generally and for forensic social anthropology in particular? In relation to social anthropology, firstly, the model clarifies the object of social anthropological expertise as human sociality. Sociality is an observable and measurable attribute of human behaviour involving individuals, relationships between individuals, and types of relationship. As with all scientific objects, sociality is intuitively familiar to most people, and most people are able to clearly classify discrete and intersecting spheres of their own sociality according to domains of experience, such as, for example, family, friends, school, work, commerce, sport, religion, ethnicity, nationality, and so on. Also, as with all scientific fields, a three-part model of social anthropology elaborates this intuitive understanding of sociality by formalizing it and introducing empirical data and methodologically relevant technologies that harness that formalization to make empirical measurements. By using a formal definition of sociality, measurement of variations in that sociality are made much more reliable and meaningful for the purposes of research, and especially for courts. With respect to the metric parameters of sociality, one of the most powerful empirical measurements that can be made is the distribution of real and specific relationships linking individuals together across geographic space and historical time. An obvious example is that of an individual life path, in which distinct types of relationship form at different points in time, starting with a child's relationship with their mother, followed by their relationships with other primary carers, siblings, then school friends, teachers, professional colleagues, ideological allies and enemies, lovers, and so on. These relationships also exhibit spatial distributions that reflect an individual's geographic movements over the course of their life, as well as the course of the lives of those with whom they interact. The result is, of course, extensive and theoretically continuous networks of human interaction spanning the entire planet and all of human history. With respect to the technological basis of these metric parameters, a formal definition of sociality building on the three-part model of science makes it possible to collect data, build models, and conduct analyses using leading-edge technologies. One of the unusual features of mainstream social anthropology, or what we might call the philosophy of culture, is that it remains notably low-tech, despite the existence of relevant, cheap, and powerful computer hardware and software for more than 3 decades. This includes relational database management systems, social network analysis software, geospatial information systems, and accompanying information communication technologies, or what we could call ICT, which have opened the door to fine-grained and very large-scale modelling and analysis of complex social dynamics. Each of these technologies, especially when used in combination, provides powerful means for measuring variations in sociality across time and space, including not only individual life paths and one-to-one relationships between individuals, but also entire communities of individuals linked together by theoretically infinite numbers of relationships of many different types, each of which exists at distinct periods in time over distinct regions of geographic space. Finally, with respect to causality, a formal and empirical social anthropology based on this object provides a causal model for predicting observable patterns of variation in sociality. The most developed theories of culture currently accepted agree that culture constitutes a process of cumulative feedbacks between collectively held ideas about social relationships and the instantiation or realization of those ideas in the formation of real-world relationships. While ideas comprise the motivation for forming relationships, pre-existing relationships form the basis for the generation of ideas and the modification of existing ideas. The ongoing basis of this feedback gives rise to characteristic patterns of both relationship and ideas that exhibit distinct regional variations in space and time between human communities, in a process that we might refer to simply as culture. Using the previous example of an individual life path, a child's primary carers are responsible for explaining the idea of family and later of school. Once the child begins attending school and forms relationships with teachers and other students, the ideas propagated there reinforce the child's ideas about the distinction between family relationships and school relationships, but also elaborate those ideas and extend them to anticipate ideas about working relationships, which the child later goes on to form once they finish school. Ideological relationships emerge from the nexus of these different domains of experience. Thus, while sociality is the object of social anthropology, culture is the causal model that social anthropology uses to predict observable patterns of sociality in distinct regions of space and time. This brings into high relief the insignificance of the distinction between names for the field as either social or cultural anthropology, since the only distinction is whether focus is given to the object or causal model of the field, when in reality, both are inherent to the field as a whole. The implications of the three-part model of science for social anthropology forms the basis for the field's specialisation in a forensic setting. Now we move to the specific instantiation, if you like, of that formalisation in a forensic setting here in Australia. This section looks at the practice of forensic social anthropology in Australia. While discussions persist internationally about the future direction of social anthropology as a discipline, the application of this three-part model in the context of Australia's legal administrative environment has proved highly functional. In this setting, it is not the academy that propagates a science of social anthropology, but rather the judicial system, through its enforcement of a collection of codified conditions on the structure and function of social anthropological evidence that it considers. Although forensic social anthropologists in Australia are engaged across a range of legal settings, including consumer rights, child removal and family violence, migration and asylum seeking, the great majority of social anthropologists are employed primarily in what has been termed the native title sector. This is a sector in which, apart from the federal court, the Australian federal government is the primary participant, being both the authority responsible for enforcing the Native Title Act, the Commonwealth Native Title Act of 1993, and for funding the majority of other participants in the sector, including, most importantly, the corporate representatives of Indigenous community native title claimants. These latter participants are made up primarily of Indigenous-run, government-funded corporations known collectively as native title service providers, which employ social anthropologists as either internal staff or external contractors. Because the primary function of social anthropologists employed by native title service providers is to provide evidence to the federal court, they are de facto engaged in the practice of forensic social anthropology. The primary role of these native title service providing anthropologists is to demonstrate three things as far as the federal court is concerned. One, the existence of one or more distinct Indigenous societies with distinct sets of rights and interests in specific geographic areas, including lands, waters, and natural resources. Two, the existence of distinct so-called laws and customs, or what we should properly call systems of ideas, which are observed and instantiated by members of those societies as a means of regenerating both themselves and their interests in the geographic areas claimed. And three, the persistence of those societies, as well as the laws and customs, and the rights and interests that they claim over time, from the moment at which Britain asserted sovereignty over the particular area that the claim is being made, and the moment when the native title claim was lodged. The forensic specialisation of social anthropologists working in the native title sector is formalised, as will become increasingly important as we move forward, by what is called the Federal Evidence Act of 1995, which works in conjunction with the Native Title Act and any other piece of legislation for which an Australian federal court plays an administrative role, including not only the federal court, but also the High Court, to which appeals in the federal court system are referred, the Family Court, which I might say in the last couple of weeks has been effectively liquidated by our current government, and the Federal Magistrates Court. In the case of the Native Title Act, the federal court plays a primary determining role in hearing claims by predominantly Indigenous applicants to determine the existence of native title rights in land, waters, and natural resources, and in giving directions to parties to enter into mediated negotiations prior to, or as an alternative pathway to, litigation where claims are opposed. Such claims are typically opposed by multiple respondent parties in Australia, usually led by Crown solicitors, acting on behalf of state governments that exercise regional control or regional jurisdiction over the areas where the native title claims are being made. So we have this odd situation in Australia where the federal government is responsible for supporting and funding the corporations that represent and advocate for Indigenous native title claimants, while the lower level state governments actively oppose these native title claims on a state by state and territory by territory basis. Under these circumstances, social anthropologists are bound by rules of evidence set out in the Evidence Act, which impose conditions on the form that evidence must take in order to be admissible to the court, and on anthropologists' duty to the court. On this last point, social anthropologists engaged in the submission of evidence in native title proceedings are explicitly bound by a duty to the federal court above and beyond their duty to their employers or clients. Given the partisan history of social anthropology in Australia, this statutory obligation has provoked some tension between many, although not all, social anthropologists who perceive themselves as advocates of Indigenous claimants, and the federal court, on the other hand, which is obliged to ensure impartiality when considering evidence in legal proceedings. In some circles, this tension has given rise to open accusations by anthropologists working exclusively in Australian academia that forensic anthropology is somehow a subordinate subfield of a more pure domain of research. Despite the now 28-year-old formal role of forensic social anthropology in Australia, following the introduction of the Act in 1993, no formal certification frameworks or uniformly accepted guidelines exist for ensuring minimum required standards for the engagement of practitioners beyond those set by the Commonwealth Evidence Act and variations on the Evidence Act applied by state governments, variously known as Native Title Evidence Guidelines. The Australian Anthropological Society, the AAS, which is the voluntary learner society for social anthropologists in Australia, does not offer certification or practice guidelines of any kind. Although the Centre for Native Title Anthropology at the Australian National University offers a specialised master's level qualification in the practice of what they call applied anthropology under the stewardship of highly experienced practitioners, its training framework has not been replicated outside of that university nor adopted by existing regulatory authorities. The absence of a formal certification framework in Australia means that minimum standards for the practice of forensic social anthropology are absent. There are no agreed methodological or theoretical frameworks for the demonstration of key facts required by the Native Title Act for proving the existence of Indigenous native title rights and interests, including the definitions of law and custom, society, or continuing connection, so-called, to areas of land and waters under claim. While significant innovation has occurred in some parts of Australia with regard to the form and function of such evidence, particularly in the southeast of the continent, there is no formal mechanism within the native title sector for such innovation to be considered for adoption as standard practice. This regulatory vacuum for forensic social anthropologists stands in marked contrast with the regulation of forensic physical anthropologists in Australia. In February last year, the Australian-New Zealand Policing Advisory Agency's National Institute for Forensic Science released the second edition of its guidelines for forensic anthropology practitioners. The National Institute is established by a formal agreement between various Australian and New Zealand forensic service providers and forms a directorate within the Australian-New Zealand Policing Advisory Agency, which is itself established by a formal agreement between all Australian state, territory and federal police forces, together with New Zealand Police. The National Institute's 2020 guidelines represent a minimum set of methodological and ethical standards for forensic physical anthropologists to follow when conducting examinations, producing reports, and providing expert evidence in court. The guidelines provide a clear set of terms and definitions, setting limits on the practice not only of forensic physical anthropology, but of physical anthropology generally. Most importantly, they require that practicing professional physical anthropologists hold a doctoral degree in physical anthropology or human anatomy and be members of one or more affiliated institutes. At 28 pages, the document is clear, concise, and powerfully functional. A similar level of regulatory discipline for forensic physical anthropology exists, of course, in the United Kingdom, which is governed by the Code of Practice for Forensic Anthropology. Working in conjunction with the forensic science regulators' codes of practice and conduct, those guidelines detail standards of practice which are expected for forensic physical anthropologists undertaking both Crown and Defence work within the criminal jurisdictions of the UK. A striking difference with the Australian regulations, however, is that the UK guidelines are jointly developed by the National Forensic Science Regulator and the Royal Anthropological Institute, the voluntary learned society for both physical and social anthropologists in the UK. In fact, as we know, thank you, David, the president of the Institute is, of course, the well-known and influential forensic physical anthropologist, Professor Dame Sue Black. There is no substantive reason that forensic social anthropology in Australia could not be similarly regulated. As leading forensic social anthropologist and professor of anthropology at the University of Queensland, David Trigger, points out in 2013, quote, "In Australian social anthropology, there is not necessarily a widespread understanding of what the legal system requires and how those requirements may confront some common aspects of anthropological practice, including data collection and analysis," end quote. However, in addition to the very specific requirements of the Commonwealth's Evidence Act, existing case law provides a clear illustration of what Australian courts expect from social anthropologists in the provision of evidence. One especially resonant example of such case law is that provided by Federal Court Judge Justice Selway in a 2005 decision regarding a native title claim in the Arnhem Land region of far north Australia. And Justice Selway says, quote, "There are at least two specific problems which seem to recur with social anthropological evidence in litigation concerning Aboriginal rights. The first is the perceived problem of partiality, where the evidence has more the ring of a convinced advocate than a dispassionate professional, and which may even affect its admissibility. The other specific problem relates to the form in which written anthropological reports often seem to be prepared. These often seem to be in the form of a book, setting out various facts and conclusions in an interesting and informative way, but often there is no obvious link between the methodology adopted by the expert, be it observation, discussions, reference to the published literature, or the expression of an opinion, and the apparently factual matters stated in the report. Presumably, reports in that form are appropriate and accepted within the field of anthropology." And of course, he means social anthropology, end quote. Similar frustrations have been expressed by federal court judges in other native title decisions, including noticeably Justice Sackville in the case of a native title claim brought by Indigenous owners over one of the most widely recognised sacred sites in Australia, Uluru, or what many may know as Ayers Rock. In his decision, Justice Sackville notes that, quote, the anthropologist's evidentiary report did not conform with the evidence given by Indigenous witnesses, and the approach taken in the report did not conform with the way in which the case had been presented by the applicants. The anthropologist expressed the basis for his opinion in such general terms that the reasoning process underlying the report was insufficiently clear, and parts of the report appeared to contain advocacy rather than expert opinion, end quote. And it is noteworthy, I should say, that in both these native title claims, the forensic social anthropologists engaged to present evidence were highly experienced and both held professorships at Australian universities. So there is no question that's their expertise. Under these circumstances, Australia faces an unusual situation in being home to possibly the largest community of forensic social anthropologists in the world as a consequence of the native title sector's demand for their expertise, while at the same time lacking any formal guidelines or certification framework for the practice of forensic social anthropology. Despite this lack of regulation of one field of anthropology, the other field, physical anthropology, maintains a mature and well-regulated community of specialised forensic practice. The oddity of this situation is highlighted indirectly by Dominguez and Ross in 2016 in their foreword to a special edition of American Anthropology, incorporating a subsection on forensic anthropology. The foreword includes interviews with 4 practicing forensic physical anthropologists, one of whom, Dr. Soren Blau, is a long-serving member of the Victorian Institute of Forensic Medicine, based here in Melbourne, which is one of the approved affiliate institutes that I mentioned earlier, allied with the National Institute of Forensic Science. And what she says is this, or rather I should introduce her comments. American Anthropology is, of course, a journal of social anthropology, mainstream social anthropology, and the interviews conducted by Dominguez and Ross are framed as a sort of intellectual exchange, right, between 2 fields of a single parent domain. And in some cases, this is apparent in the awkward misunderstandings of some of the subtexts behind some of Dominguez and Ross's questions, which I might say are a bit provocative in parts. Now, nowhere in the interview does Dr. Blau make any reference to forensic social anthropology, and there is no indication on the parts of Dominguez and Ross, who are social anthropologists, that either they or Dr. Blau are aware of the existence of forensic social anthropology practice in Australia. Although by that time, there had been published a very important work by David Trigger and a number of other senior forensic social anthropologists, eponymously titled Forensic Social Anthropology. Now, what Dr. Blau does provide in her very gracious responses to this line of questioning is a clear and concise articulation of the expectations that Australian courts have of forensic physical anthropologists, and the latter's ongoing efforts to self-regulate, to regulate their own specialised practice as part of their interactions with the court system in Australia. Now, what this brings us to is the dynamic between the practice of social anthropology in its specialised form and the expectations of a court system regarding expert evidence. Australian social anthropologists really have been unwitting participants in possibly the most extensive administrative experiment in unilateral formalisation of an academic humanities discipline by an Anglophone government since the Second World War. In this case, the Australian federal government legislated through the National Native Title Act the federal court's role in setting demands that the discipline of social anthropology provide evidence for the restitution of Indigenous rights in lands, waters and natural resources previously expropriated by colonial governments. How can this experience of forensic social anthropologists in Australia contribute to a paradigmatic reconciliation between the forensic specialisation of the 2 fields of the parent domain of anthropology, while at the same time enshrining their critically different models of biological and cultural causality? As outlined earlier, the forensic specialisation of any scientific field brings the object and causal model of that field to bear specifically on matters in which a court acts as a determining authority. Courts become involved in determinations either when they have been legislated as the appropriate authority, such as in Australia's native title sector, or when other administrative mechanisms for determining questions of rights, interests, and obligations have been exhausted or do not exist. Both forensic social anthropology and forensic physical anthropology share in common this relationship to courts, along with the broadly standardized structure and functions that characterize court operations. These structures and functions include the role of expert witness that anthropologists are expected to perform for the court. In this context, the regulation of forensic expertise is ensured both by the courts and by the self-regulation of the professional disciplines in which forensic specialists practice. In this way, forensic specialisation spurs formalisation of a field by bringing to bear an external demand for probative empiricism as well as formalism, while the field responds to that demand with regulatory frameworks that reflect its own best practice standards. In this way, forensic specialisation provides an incentive for the formalisation of social anthropology and its anchoring in empirical evidence-based data collection, modelling, and analysis. This incentivisation in turn opens up a demand for data, technology, and enhanced methods that have been developed in response to the evidentiary pressures of the court system. This is especially the case where the restitutive function of forensic social anthropology is applied to mass casualty events, such as natural and man-made disasters, including, in the latter case, armed conflict. A common point of contention in many native title claims and negotiations is the accepted time and location of what is euphemistically referred to as the assertion of British sovereignty at various locations around Australia. This phrase usually refers to a forced expropriation of specific lands and waters by British colonists or some branch of the British government or military. The Indigenous survivors of such events are typically referred to as the apical ancestors, that is, the ancestors at the apex of a kinship network-based community. The apical ancestors of native title claim group members from whom hereditary descent is traced as a means of identifying living claimants. The identification of apical ancestors and their descendants bears much in common with what forensic physical anthropologists refer to as disaster victim identification, albeit via triangulation of oral and written sources in a sociometric analysis rather than in terms of a biometric analysis of skeletal remains. This is where the primary utility of formal empirical social anthropology becomes relevant to forensic application. Recording, modelling, and analysing the social relations that trace the life paths of disaster victims and survivors, and which link disaster victims and survivors together into complex, culturally based networks is the key objective of forensic social anthropology. In much the same way as administrative authorities are agnostic on whether or how many individuals have survived the disaster, Australia's Native Title Act assumes a default state of affairs in which the existence of Indigenous Australian traditional owner communities and their relationships to their lands, waters, and natural resources remains unknown until demonstrated and subsequently determined by the courts. The role of Australian forensic anthropologists working in the sector is to demonstrate, firstly, the existence or non-existence of those communities, and secondly, conditional on their existence, the further existence or extinguishment of those communities and their relationships to those lands, waters, and natural resources. Similarly, in a disaster setting, the role of forensic physical anthropologists is to determine the existence or non-existence of one or more individuals at the disaster site, and secondly, conditional on their existence, the further existence or extinguishment of those people's lives. In fact, the Australian Native Title Act uses the term extinguishment to refer to any so-called act that is considered to have annulled Indigenous rights to lands, waters, and natural resources, including those acts that sufficiently disrupt a community, such as massacres, systematic child removal, and forced population movement. Documentation and analysis of these types of historical crime typically form a key focus of forensic anthropological research in the native title sector. However, this exercise is not unique to Australia's native title sector. The International Criminal Court, the International Committee of the Red Cross, and Justice Rapid Response all stand to benefit from the contribution of this type of expertise if a standardised code of practice can be established and a reliable regulatory framework adopted in line with best practice, methodological and ethical terms and definitions, and forensic anthropology is able to stand up to contribute its expertise beyond Australia. So, in conclusion, what can the now 30-odd-year-old Australian experiment in forensic social anthropology teach the world about the potential consilience between the two erstwhile child fields of anthropology, physical and social anthropology in a forensic setting? What does the nearly 3 decades-old interaction between social anthropology and the federal court in Australia tell us? 1, it clearly defines the object of anthropological research as society. Drawing on the most advanced equivalent terminology, we would formalise the definition of society as that community comprised of particular individuals, particular relationships between those individuals, and particular types of relationship. 2, the interaction between social anthropologists and the Australian Federal Court provides us with parameters in space and time. In this country's case, the period between 1788, when Britain first invaded Australia, and the present, inclusive of those more specific periods that commenced later as British colonists pushed further out from their beachheads, and the contemporary points in time when affected Indigenous parties have been able subsequently to lodge their claims in court. This exercise illustrates what the parameters of a social anthropological study of a disaster or other mass casualty event would look like in other settings, both within and outside of Australia, where the time and location of events extend outward, geographically and historically, according to a causal cultural relevance. Finally, 3, the interaction provides, albeit clumsily, a definition of society as a complex entity that arises from the continuing observation or instantiation of particular laws and customs by its members over time, such that the relationship and the types of relationship that constitute the society are predictable products of that observation. The law in Australia thus provides us with a model of causality, and in requiring that the object of social anthropological research arises from the systemic instantiation of culturally distinct ideas in the formulation of relationships which themselves further reinforce or otherwise modify those systems of ideas. And I think that's enough talking from me, so perhaps we can move to questions. Thank you, David.
Well, James, thank you very much indeed for a paper of the utmost originality and brilliance. It was really marvelous to be able to hear such a wonderful exposition. I wonder if, before we go to questions, and please, colleagues, feel free to send your questions into the chat and also put your hand up if you would like to ask one live. But just before we kind of go into the question and answers, I wonder whether you could segue us into that, James, by talking us through an example, if you got one in mind that you could give us of one of these things in action.
Yeah, certainly. So, a very good example would derive from what's called the northwest slopes and plains of the state of New South Wales, which is what we would call a second-tier impact site in Australia. I don't know how many in the audience are familiar with Australia's colonial history, but the first British landing was at what is now Sydney, and Sydney geographically is on a coastal plain surrounded by quite impenetrable mountain ranges, which even today are all national park because of their impenetrability. And it took about 30 years for the British military, actually using Napoleonic War veterans, to be able to push north over the mountain ranges into what has subsequently turned out to be a very fertile agricultural area. And between 2007 and 2012, I was responsible for developing evidence for a native title service provider on behalf of native title claimants in that area for the federal court, ultimately, in my duty under the Evidence Act. And in that area, the Indigenous language fell out of vernacular use probably around the 1910s. You know, there have been a succession of punitive laws which have banned the use of Indigenous languages and punished parents who taught those languages to their children with the removal of their children and so on, the banning of traditional religious ceremonies. So it's been quite a long time since anybody was able to talk openly about the kinds of cultural laws and customs that the court deems to be critical to a successful claim. However, using these formal techniques, which I've described in an abstract way, to model the population and to model the idea systems of the living population, we're able to show an isomorphism between the patterns of population structure, its distribution across that region, which I might say is about 10 million hectares, and the consistency of that population structure over time from the initial incursion of the British military in the 1830s through to the present, to a degree that the court accepted, or at least the primary proponent in the first instance, opponent rather, which was the New South Wales Crown Solicitor, accepted that the evidence was sufficient to go to determination. And we've repeated that experiment with what we would call similarly impacted Indigenous landholding communities around Southeast Australia. These are all publicly available. You can look them up on the website of the relevant tribunal, which is called the National Native Title Tribunal. If you look at claims that have been determined in the state of New South Wales, you'll see the outcomes.
Well, that's marvellous. And that, of course, answers or begins to answer the second point, which will be in everybody's mind, which is, in fact, how effective even forensic social anthropologists manage to have been. Clearly, what you're implying is they can be very effective indeed if the process goes well.
Yes, well, that's right. And the subtext, or really the text of my webinar, of my paper, is that there's this tension within social anthropology between this sort of philosophy of culture as opposed to a more sociometrically oriented approach to collecting and modeling data and then searching for isomorphism between patterns in the data and patterns in people's autochthonous systems of ideas is really unnecessary. So that if we were able to just do away with this sort of tussle for control, if you like, or top authority of the field, then we might find that there are applications for the field as a whole that would actually meet the kind of ethical aspirations of most practitioners, of most social anthropologists. Yeah.
Yes, indeed. There's a food for thought. Food for thought. Well, we have here somebody who doesn't give their name, but says, if Dr. Rose doesn't touch upon this in the talk, would it be possible to ask him to speak about the network mapping graphic in the introductory slides? Thank you.
Okay. Well, you know, I get asked this question a bit because I'm a network analyst, you know, and I have developed over the course of my career this particular technique for modeling, particularly kinship networks in space and time, because it turns out that there are a number of not just forensic functions, but also very powerful communication functions, because the way that many Indigenous communities articulate their connections to country are not just in terms of their kinship cohesion to one another, but their intuitive sense for how their own kinship communities are associated very specifically with networks of locations. So actually, David, I must admit, what I've done is open up Google Earth in the background. So I'm actually running one of these models live. If I can share my screen again, and perhaps I can provide you with a fly through and narrate it. I'll see if I can share this particular screen. Is that appearing for everyone?
Yep, go ahead.
Okay, so what we have here, for those who aren't familiar, is Google Earth displayed on the screen. Google Earth is an open source, what we would call a GIS, a Geographic Information Systems platform, which uses a lovely code, or a lovely coding language known as KML, which for those of you in the room who are coders is a form of sort of HTML. It's a markup language similar to what is used to build websites. But fantastically, it allows us to build not just maps of points on a two-dimensional surface, but actually all kinds of three-dimensional forms. And so what we're looking at here is a kinship network of individuals who are the points on the screen. They are located in the places of their birth in terms of geographic space and identified, well, they're anonymized, but identified by unique numbers. So they're distributed in 2 dimensions by their birth location, but then they're also distributed vertically according to the time of their birth. So this provides us with a very powerful way of communicating what would otherwise be a quite abstract mathematical concept of geospatial, or sorry, rather spatiotemporal cohesion in kinship networks. And this technique is particularly useful in courtroom settings where you have a sort of uneven distribution of familiarity among barristers and solicitors and judges and so on, and key anthropological concepts. So the color coding here is a sort of a, I guess, a dye, if you like, that has been applied to the descendants of known speakers of particular language varieties. So, you know, I said earlier that in much of New South Wales, languages are in abeyance. People no longer speak them fluently as a vernacular, but we have enough archival, linguistic and ethnographic records and data that we can identify speakers in the past, and we're able to trace their descendants. And so what we're looking for is isomorphism between the autochthonous cultural concept of Indigenous communities, that languages are attached to certain areas of country, and the demonstrable, the empirically demonstrable distribution of language identity via kinship networks over time. And we're looking for, when I say over isomorphism, you know, correspondence between the concept that people hold intuitively as part of their own cultural beliefs and what we're able to empirically document. And of course, we can see very clearly that yes, there are very clear distributions. So we have here what is called the Wiradjuric language group, which is made up of a number of specific languages. There are 3 languages. The Northwest Slopes and Plains that I referred to earlier is in this area up here. The language is known as Gamilaroi, has a number of dialects. Down here we have Wiradjuri. In the west we have Ngayampa, and all of those languages linguistically are very closely related. So the linguistic data, the kinship data, the autochthonous cultural ideas of the people themselves are all isomorphic. They all line up. And they do this even though the language hasn't been spoken for a century. So we have the oldest people here born around about 1800. They're at the highest altitude. And we have the youngest members of society born in the 21st century down here. Yeah. So that's an example of what we might call a sociogram or a kinship network model serving a forensic function.
Well, that's obviously absolutely fascinating. And how does that fit into the Land Act from 1993? Where's the fit there?
So the Native Title Act thankfully, is actually quite flexible in terms of what it regards as admissible evidence. So it requires only those three things be demonstrated consistent with the accompanying Evidence Act, which is that there be a demonstrable society. So it has to be a distinct society. There has to be isomorphism between the claimant's assertion that they constitute a distinct society and the empirical data which shows that they're distinct. Now, as to how you demonstrate that, the court is neutral. So really it allows anthropologists fantastic latitude to be able to use whatever best practice methodological approaches they have in their armory to be able to demonstrate that isomorphism. The second demand of the Native Title Act is that there be demonstrated distinct laws and customs observed by that society. For example, language. Now, a language is effectively a form of custom. So if you can leverage sufficient linguistic data to show that the language was spoken by the ancestors of these people, as distinct from other people's, then okay. But also we have great diversity in religious beliefs and ceremonies across Australia. And then, of course, you have to be able to demonstrate, the court requires that social anthropologists demonstrate that these laws and customs, these systems of ideas, are actually observed or put into practice. Now, in a case like Southeast Australia, where language hasn't been spoken for a century, ceremonies stopped being performed around about the same time, and a lot of the mythology is now forgotten, there is still enough data that can be gathered empirically with access to the right kinds of records to be able to show, if you like, a sort of an echo in the way that society reproduces itself according to tacit ideas. So even if people are no longer able to recount particular mythologies, they do still retain a very strong sense of which sites are important, and they have the names of those sites. For example, it's an animist religion here in Australia broadly, so there are mythological, for example, kangaroos associated with certain mountain ranges, or certain species of bird associated with certain rivers and so forth. So even though the detail of the mythology is lost, where people are able to say that, oh yes, we know that this mountain is associated with, for example, the mythic kangaroo, which has a particular name, if we're able to show that enough of this kind of knowledge exists and that it has a structuring effect on the society, on the distribution of the society, over the way that members of the society interact with one another over time, then it's sufficiently compelling at a probative level for a judge to accept. Because of course, the ultimate goal is to demonstrate that the society exists and that it has a systematic association with a particular area of land that has persisted over time. Yeah.
Yeah, and the whole question, of course, of tacit knowledge and how we can make it explicit is crucial in so many contexts. And we have a question now about the wider applicability of these kind of ideas, which of course is very, very important. And the question is phrased in terms of the Uyghur situation in China. And our question would like to say, is forensic social anthropology involved in the plight of the Uyghur population in Xinjiang to prevent the attempted extinction? And if they're not involved, what can they do? Is there anything here the anthropological community at the international level can do before it's too late?
Well, of course, the situation in that region of China and Xinjiang is appalling, as I'm sure we all agree. I might answer that question with reference to the variation across Australia in the history of disasters, if you like, and the history of different points of asserted British sovereignty in space and time. So although the first fleet of naval vessels and marines arrived in Sydney Harbour in 1788, the last armed forces, British representative armed forces to penetrate parts of Australia was a century later. And in fact, in the region where I grew up in Central Australia, which is an Indigenous reserve, known as the Animal Pitjantjatjara Yankunytjatjara lands, the first contact those communities had with the colonial Anglo population was in the 1920s. And the bulk of that first contact occurred during the 1950s, when Britain was conducting missile tests and nuclear weapons tests in the same region. And during that time, government was committed to, in the wake of World War II, extracting stragglers, as they called them, Indigenous peoples from the desert. So to connect that back up to the situation with Xinjiang and Uyghurs, there is not there's not an urgent need for forensic social anthropologists. What there's an urgent need for there is legal assistance in the first instance to establish the conditions in which evidence of that kind might be useful. So we're talking about triaging relevant forms of forensic expertise according to the circumstances.
But it does bring up the whole question of the power context in which case these things are operating. Because going back to your example, the courts perhaps are on the way to being convinced. But is there then a strong enough infrastructure to then transfer the title deeds back to the Indigenous populations and ask the white population to move out? I mean, how does it work?
Well, again, I'm not sure how much of the audience is familiar with the demographic situation in Australia, but over 98% of the population as a whole lives in the capital cities, of which there are only a small number all on the coast. So the interior of Australia, to all intents and purposes, is empty, and the relative proportions of Indigenous and non-Indigenous peoples is completely different to the cities. So in the Northern Territory, for example, where Arnhem Land is located, that claim that I referred to earlier in the paper, the Indigenous population is 30%. It's very, very large proportionally. And in the region where I grew up, I was the only, my parents and my brothers and I were the only non-Indigenous people in the region, for hundreds of kilometres. So it's not so much a question of pushing non-Indigenous people out as examining what restitutive function the law can provide. So, for example, where exclusive occupation of an area of land provides no benefit, it's unlikely that Indigenous claimants will seek that. They may, for example, seek rights in natural resources where there is some benefit to the community in, for example, funding enhanced health service provision, education, justice system remediation, housing, and those sorts of essential services, rather than sort of, taking the land freehold, as it were. Yeah.
Well, that's a very, very helpful for clarification. There are several people have remarked how interesting your talk is, and they would like follow-up literature. I mean, I don't know whether it would be easy for you to perhaps send Haneen a page of references. And then Haneen will send them to the participants. Would that be the easiest way to do it?
I think so. Certainly there are volumes of literature on the native title, or what we call in Australia native title anthropology. And a lot of them are actually contained in existing registers. So I can probably just provide links to those registers.
Sure. Specifically, there are people who are thinking about this whole idea of forensic social anthropology. I mean, whether you've written a book about it yet. And one of the questions is, have you written this talk as a form of a paper? Because I'm sure many people here would love to have it if you have yet.
Yeah, no, in fact, I have, which is why I was reading it. It's unusual for me to read my papers. It sounds really boring and wouldn't, but it was so in anticipation of there being an interest. Yes, look, certainly. I've given many papers, so I've only recently moved from consulting practice as a forensic anthropologist over to academia. So my appointment as a research fellow is a new thing. I've practiced for 15 years as a forensic social anthropologist in the court system.
Right, yeah. Right. Well, I mean, I think I'm sure I speak for all of us when we say we'd love to read that. Read it. That'll be absolutely great. So we have another question here. from John Gowlett, who's John is a well-known prehistorian of Africa and a vice president of our institute and a fellow of our institute. But John says, thank you very much for your illuminating talk. It would seem that what courts need is reliable evidence presented in an accepted form. Are you yourself working on shaping rules or codes for presenting evidence? And if so, what's your main academic community in Australia that is your sounding board?
Well, I've been advocating for the implementation of standards around the form of forensic social anthropological evidence, specifically in relation to native title, but also in relation to other issues around health provision and child custody for 15 years. What's interesting is the variable responses from different quarters of the audiences, at those symposia and conferences. So often what we find that people who work in the health sector or in industry or in finance are actually the ones who are most energized by the idea of a standardized system, because of course standardization provides certainty to people who contribute to intersecting sectors or industries, if you like. Now, unfortunately, the issue of Indigenous rights in Australia is so heavily politicized that the real challenge is in advocating for standardization is actually in overcoming intransigence on the part of the legislative branch. Because of course it was the federal government that legislated the Native Title Act, which in turn empowered the federal courts to make decisions. And that legislative act in 1993 came off the back of a groundbreaking court decision, which was actually a dispute between two Indigenous people in the Torres Strait, which is between Australia and Papua New Guinea, about the authority of the Australian court system to make decisions with regards to disputes about traditional forms of title, when the two parties were Indigenous. Now, the federal court, and this is called the Mabo case, after the name of Eddie Koiki Mabo, who was the main proponent. The federal court, in hearing this matter, this dispute, and of course, one of the parties was joined by the Queensland government and Crown Solicitor, the federal court decided that it didn't have the power to make a decision with regard to Indigenous disputes based on hereditary traditional title. And so the matter was referred up to the High Court. And the High Court made this decision that in order for the Australian judicial system to be able to make decisions about Indigenous title, even where it was a dispute between two Indigenous landholding groups, it had to ingest the entire system of Indigenous native title rights into common law theory. And so, short of an amendment to the Australian Constitution, this is profound. Now, two things could have happened at that time in 1993. The government of the day could either have ignored the court's decision and just hoped it would go away, in which case the highest legal advice at the time was that there would be this slew of similar challenges in the federal and high court, which would be very destabilizing for Australia politically as well as legally. And the other view, which was considered more pragmatic, was that, well, if we legislate around this uncertainty, we can contain it. And we can, if you like, set the terms on which Indigenous claims to restitution will be considered. And that's in fact what happened. And so the Native Title Act was legislated. However, in terms of standardizing the practice of forensic social anthropology and its intersection with the law in Australia, it is considered such a fine-grained issue within the broader scheme of Australia's mining sector and fisheries and so forth, all of which are compelled to adhere to this piece of legislation, that, and also politically provocative, that no government wants to touch it. But unfortunately, without appropriate amendments or augmentation to the guidelines, we remain stuck where we are. Of course, I mean, there are other authorities, statutory and otherwise, which could develop guidelines. But again, they deal with the political challenge of having their funding manipulated and so forth. So it's a complex political situation.
Yes, I mean, the fascinating thing here is, of course, social anthropologists such as myself, and such as indeed a question here, who have actually submitted expert reports and so on to the court, but haven't been asked to necessarily phrase them in this way. And indeed, the British understanding of the use of expert witnesses in anthropology in my lifetime appears to have changed. So when I first began, I was writing reports, although they weren't called forensic social anthropology, we're not a million miles away from what you're saying. In other words, I was asked to give a factual assessment of the situation. But within about a decade, that changed. And I was only asked to give a cultural assessment of the situation, which is something like this, which is it conceivable that the defense or vice versa, the claim made by the prosecution, is in fact logical within the parameters of the culture in which you're an expert? And so I was explicitly asked not to address the evidence at hand, which made me very cross, because I wanted to say whether it was made up or not. But no, I was only asked to speak at a very general cultural level, which appears to be the opposite of what you're saying. So as far as I can see there, the British court system, in this respect at least, is moving away from forensic social anthropology. But I don't know whether you have any thoughts about that.
Well, no, look, I do, because in fact, the Native Title Act emerged out of an earlier regime known as the Land Rights Act. And now we had a very progressive, and borderline revolutionary government during the mid-1970s, which engaged in a sort of a similar form of empowering the courts via new legislation in order to make decisions about Indigenous rights. In the 1960s, again, in Arnhem Land, which is a culturally very dynamic region in Australia, there was a bauxite mine. Bauxite is used to make aluminium. And the mine was built without consent in the territories of the Yolngu-speaking people, who are, very strong self-governing polity, and remain so to this day. And they lodged a legal challenge to this court being built in their lands, which at that time was administered by a sort of a missionary style authority. And this generated a similar kind of insecurity. Now, because this was the 1960s and there were decolonisation movements bubbling up all over the world, and Australia was also at that time facing a domestic crisis of population movement because our economy was reorganising due to changes in the international cattle market, not to get too fine-grained about it, but there was a lot of population movement, and the government was a bit anxious that we could see the emergence of a sort of a militant Indigenous insurgency. And the response of this very progressive government that we had at the time was to implement what they called the Land Rights Act. Now, this was not a litigiously based act. It was not intended to fall back on the court system. It established a tribunal, which was led by what are called registrars, and the evidence that was requested, again, was evidence from social anthropologists, but it was not of a litigious standard. So it wouldn't meet the criteria of what we would call forensic social anthropology. It was this kind of more generalist advisory kind of evidence that were being presented, very consistent with what a lot of us would be familiar with as expert evidence. You don't need to be a forensic specialist to provide an expert opinion. You can provide your evidence in the form of an affidavit, for example. And that was the era, from when that act was passed, that law was passed in the 1970s through the 1980s, in which most social anthropologists who later went to work in native title cut their teeth. And so when the Native Title Act came into force, and it, although it was a litigiously oriented framework, we had this community of practitioners who were used to providing this sort of, for want of a better word, lower level or lower probative form of evidence. And part of the hostility or the antagonism that's developed towards the legal system in Australia is because of that sudden gear change in demand by the court system and tribunals, the legally empowered tribunal system in Australia from social anthropologists. So yeah, look, and I've got to say, in other areas of law, particularly around child custody and copyright and so forth, it's not necessary to meet that sort of forensic level of evidence. It is still possible to act simply as sort of an expert witness, as one would conventionally do.
That's really fascinating, because of course in Britain, forensic anthropology, as you rightly said, is often around death, which is why they need to have really the very best that they can possibly achieve. And it's helpful to understand that. And Howard Gannaway would like to ask a question, and he says that cultural beliefs and narratives change over time, naturally in brackets anyway. Do the Australian tribunals accept the association of threads that have themselves changed over time?
Yes, well, of course. So, and this has been established because the Native Title Act is based on common law. The precedents gradually accumulates over successive decisions, and judges hearing new claims will refer to previous decisions in order to guide their determinations based on those previous decisions. There has emerged a body of case law that identifies what are called adaptations to laws and customs as an acceptable form of modification, and that was critical to, for example, that claim in the Northwest slopes and plains that I worked on, because of course, unlike in Arnhem Land, where the language is still vernacular, Yolngu is still spoken as a vernacular language, the ceremonies are very much alive and well. The religion is very, very vital. In the Southeast, those things are non-existent. So it was very important to leverage the case law around adaptation. Yeah.
Well, thank you. And Mark Brightman would like to ask, do you have any reflections on the recent human rights ruling on climate change, which affects the Torres Straits Islanders?
Do I have a view personally?
Wait, the exact word, if the question is reflections, I guess you can reflect upon that as you might want to.
Sure. No, look, I can. There's a few different perspectives that I could take on this issue, depending on which dimension of the relationship between mainland Australia and the Pacific and the Torres Strait I could take. For example, the Australian agricultural sector is critically dependent on labourers from the South Pacific and from the Torres Strait to a lesser extent for seasonal work, seasonal fruit picking, and there is an established tradition of seasonal migration from the Pacific Islands or the Torres Strait into Australia to undertake that work. Now, during the pandemic, the height of the pandemic last year, when Australia shut its borders, of course, none of these labourers were able to come to Australia to engage in that work, and there was huge financial loss to parts of the agricultural sector as a consequence, because they weren't able to harvest. Conversely, there was a huge financial loss to that part of the Pacific because of all of the remittances, the money that would normally be channeled back into those regional economies. Now, Australia, as you know, is the second highest emitter of greenhouse gases per capita, and this is having an acute effect in the Torres Strait. And there is a real question around Australia's ethical and legal obligations, especially when there is this underlying financial and trade interdependency between the two polities. I think that's about as specific as I could get. Yeah.
But he also has a subsidiary question, and he says, is it worth comparing Brazil, where the institutional framework for anthropological evidence can contribute to native land claims, is in fact in crisis?
Yes, very much. And in fact, some of the most familiar discussions that I've had with international colleagues have been with Brazilian social anthropologists. The similarities between Australia and Brazil in terms of the size, the diversity, and the history and the distribution of the indigenous population of Brazil are very interesting. to consider. The big difference, and of course, I say that large regions of the Amazon are very remote, in much the same way that large regions of arid Australia have been very remote up until very recently. But the big difference between the two countries is, of course, the political stability. So Brazil was a dictatorship run by a military junta until the 1980s. And the ability of the political class in Brazil to be able to enforce the laws that do exist for protecting and ensuring the integrity of Indigenous rights to lands is much weaker in Brazil than it is here. And of course, the military situation in Brazil is completely different. Australia is a very stable country politically and economically.
Yes, yes, yes. And there are several questions around the applicability of this kind of forensic anthropology to other countries, particularly Britain, and whether there's indeed, and Atias, whether there's something here the RAI should be involved in, whether in general terms there is a use of scientific social anthropology or forensic social anthropology. What do you think?
Well, I don't know about the UK, certainly because the history is so volatile, but in terms of population movements and so forth. But certainly in other parts of the world where are facing, we are facing neo-colonial social engineering exercises, there is certainly an application. And starting with Australia's neighbours, we would look at the situation in West Papua, which is a territory of Indonesia. It was a Dutch colony up until 1962. There was a decolonisation process the Dutch were undertaking in line with its decolonisation, peaceful post-war decolonisation processes in other countries. But the Indonesian government based out of Jakarta invaded militarily. There was actually a military altercation with the Dutch Navy, and the Indonesians sent in paratroopers. And the primary motivation for Indonesia at that time was, well, one, to consolidate its territorial holdings across the archipelago, but also there's a very profitable mine in the highlands of West Papua. And West Papua is a very diverse, very densely populated Melanesian region, similar culturally to Papua New Guinea, which is, of course, part of the same island. But there's been, and they're currently actually, as we speak, very violent and forceful crackdown by the Indonesian military on Indigenous West Papuans who are attempting to assert their rights to their own land. And it gets very little coverage in Australia. But if we consider the historical experience in Australia, where similarly violent crackdowns by British colonial forces in Australia repressed Indigenous resistance, then we have an opportunity here to apply post-war ICC-based standards of evidence and of human rights, and also rights under the United Nations Declaration of Indigenous People, I would add, to the situation in West Papua. And there are similar situations in other parts of the world, for example, in Botswana, in South Africa, in Namibia, parts of Southeast Asia, of course. We know in Myanmar, which is a very ethnically diverse part of the world in terms of its Indigenous peoples, there are many, many regions of potential application for forensic social anthropology.
Well, that really does give us food for thought about the way forward. I think we're more or less through the questions, but could I just ask you for something that has been puzzling us, which is, given this extraordinarily developed discourse, in some ways very successful, it gives, in other words, something that gives us cause for hope. How on earth did Rio Tinto suddenly blow up the mines of an how did the mining company suddenly blow up something which was extremely important for the Indigenous community? I mean, this is absolutely astonishing, and I don't know how you can explain that to us. So we'd love to hear your interpretation.
Well, look, the Juukan Gorge, as it's known, falls within the territory of a group known as the PKP. Now, they have had their native title rights and interests determined by the court as existing, and have been, as a consequence of that determination, in negotiation with relevant mining companies operating in the area over how mining is able to continue in such a way that there are employment and education benefits for the native title holders, for the traditional owners of the area, while at the same time maximising protection of cultural assets, like, for example, the 46,000-year-old human hair belt, DNA tests of which showed direct connection with the surviving community in that area. Now, the Pilbara region of Australia is fairly remote, so that population hadn't been severely impacted as people in other areas, and is reasonably intact as a result. But the persistence of some of the mining companies that operate in Australia to extract every last metric ton of ore should not be underestimated. And in fact, some of the mining companies that operate in Australia to the highest ethical and humanitarian standards operate in overseas jurisdictions where there is less regulation and oversight to an even lower standard. They will hire militias, for example, to repress local Indigenous resistance to these mining operations. By contrast, in this situation, the Indigenous native title holders had actually agreed to the destruction of some areas of the surrounding country by that mining company in exchange for certain concessions, primarily financial, monetary concessions. But I think what happened in this sort of very complex contractual back and forth between the mining company lawyers and the Indigenous communities lawyers, there was a sleight of hand by which the mining company was able, under a very aggressive executive leadership, their CEO has subsequently been sacked by the board, and the community themselves. So the community was unaware that this destruction was going to happen. But these are complex, very asymmetric negotiations, and they're happening all over Australia.
Well, thank you very, very much indeed. I can say on behalf of everybody here that this was one of the most original talks I think that we've ever had. So I'm really absolutely delighted, and I really do hope this gives us a whole new way of understanding our discipline, and of course relates to our very big conference on anthropology and conservation, which is coming up in October. So there's another reason to be pleased. So thank you very much. We're sorry to have taken you away so much of your evening away from you, but we're nevertheless very, very grateful to you.
Wonderful, and thank you so much, David. Thank you so much to the Institute. Thank you to all of the participants, and of course I'd like to acknowledge also Baroness Professor Sue Black, if she's still there, for also listening to the presentation. Thank you, everyone.
And finally, Sue says she's sorry she had an executive meeting, but she'll be in contact.
Wonderful. That's very exciting news. Thank you, David.
Thank you very much. Thank you very much indeed, and good night, everybody.